Good morning, Judge Stevens. How are you? I cannot hear you.
That would be because I still was on mute.
Okay. We are still waiting for representative from the plaintiff, and I can let you know when they're all present. We are live streaming this hearing to YouTube.
Mm-hmm.
And okay. We also have the court reporter. They are currently present as well.
Okay. I'll just go dark for the next 5 or 6 minutes. You'll send me a text when it's time.
I can pop on when when we're ready.
Great. Thank you.
You're welcome. Good morning, Judge Stevens. It looks like we have representatives for both the plaintiff, defendant, and the court reporter all present, and we are ready to start the hearing whenever you're ready.
Please invite them into the courtroom.
You're good. Good to go.
Good morning.
Good morning, Judge.
This is the case of the Macomb County Restaurant Association versus the Michigan Department of Health and Human Services and Elizabeth Hertel. Counsel, would you be kind enough to state your appearances for the record?
Yes, good morning, Your Honor. Sean Kelly on behalf of the plaintiff, the Macomb County Restaurant Bar and Banquet Association.
Your Honor, Albert Addis, also on behalf of the plaintiff. Mr. Kelly will be doing the arguing today.
Okay, I would tell you that you are not visible.
Well, we have some computer and lighting problems. We don't know how quite to make me visible, but I will not be participating. I just want it on the record that I'm present.
Okay, thank you.
And good morning, Judge Darren Fowler from the Attorney General's office on behalf of the defendants this morning.
And Mr. Fowler, I appreciate that you're standing, but please don't. Okay. We've gotten used to, I guess we turned into those California courts that we used to see on TV where everybody sits down, but you may as well. There is no good reason to be standing. We have our court reporter here, Ms. Mapp. Ms. Mapp will probably likely say nothing, but if at any point in time during this proceeding, she cannot hear or cannot clearly understand what is being said, she will go live and ask any one of us, myself included, to please repeat or clarify what was being said. This is a motion to return this case to the Macomb County Circuit Court. We know from the record that it was initially filed there, that the defendant moved to transfer it to the Court of Claims. We have received both the motion to return it to the Circuit Court and the response. And this is your opportunity to amplify whatever you think needs to be amplified for the record. So I guess we begin with you, Mr. Kelly.
Thank you very much, Judge. Well, first, obviously, we'd like to rely on our motion and our briefs. We feel that this has been briefed rather thoroughly, although, of course, we were limited in our reply brief. So there are a number of things that I'd like to get on the record in case there is some appeal on this. First, the defendant's main thrust in their response to our motion was that there be some statutory enactment or statute that stands for the proposition that the state is subject to a jury trial. And we simply don't see that language in section 6421 post-amendment, the 2013 amendment. The plain language of the statute is very clear that nothing in this chapter deprives the circuit court of jurisdiction to hear and determine a claim for which there is a right to a trial by jury as otherwise provided by law, Your Honor. It says law. It does not say statute. It does not say statutory enactment. And there are a number of different ways in which litigants can avail themselves or have the right to a jury trial, both statutory and constitutional. And to the extent that it's determined by the judiciary that there is a right under either a statute or a constitution. So you have that dimension where it's constitutional, statutory, and judicial to a certain extent. And so we obviously understand the defendant's argument that there is a fair amount of background here for statutory construction with the section 6421 amendment in 2013. We looked at a number of secondary sources to determine the legislative intent as to what that statutory amendment was enacted for, and they at best do not agree on a number of different fronts. There's this bifurcation that's contemplated in Section 2, where circuit court judges will have the monetary damages that a jury trial right exists for. And then in the equitable and declaratory relief portions, the Court of Claims, now the Court of Appeals judges rather than Ingham County Circuit Court judges, will hear the other side of that. If you look at the compiler's notes, it even talks about the possibility of adding circuit court judges as a result of this. So this argument that somehow and this is Elia or Elia Companies, I apologize if I'm butchering the name of that case, that somehow this exception would swallow the rule as it exists in this new Section 6421 amendment. This is contemplated by this and the addition of these circuit court judges to handle this sort of thing. We also see where sometimes exceptions do swallow the rule, or at least to a certain extent. We don't even believe that occurs here. There's a number of different cases where in equitable and declaratory relief, the cases will be in the Court of Claims, that litigants will want to be in the Court of Claims rather than assert a jury trial right, because it does say if asserted. Okay, so you have all of these things in here that basically funnel down to the fact that the exception does not swallow the rule. But even if it did, we see that occur quite often. We see it in the Fourth Amendment. We see it in evidence rules with hearsay. Hearsay is not allowed, except that it is in almost every instance with all these exceptions. I also want to fall back on Michalski versus Barlevik. That's a 2001 Michigan Supreme Court case in which it says that, and we cite this in our reply brief, very simply, that if there is no ambiguity to the statute, then no statutory construction is allowed at all. And so by looking back into the supposed impetus for why this 2013 amendment came about, we see that because it is so plain language. It doesn't say a jury trial, a constitutional jury trial right against the state. It simply says as provided by law. And so because this is so plain, both 6419 making 6421 the operative exception clause, we see no reason why to look back even at the at statutory construction reasons. There is a case, it's Lumley. It's a 1996 case, and it talks about the clear intent under section 6421, in which it says that it was clear that the state wanted cases against the state to be tried in front of a judge rather than a jury, except that was the old version of 6421. Okay, that no longer could apply because 6421 opens up, as does 6419, that except as provided in 6421. Okay, so I think that's a very important point to make, that if we even were looking at the underlying intent, that no longer applies because the 2013 amendment has changed this so much. Defense has also argued that we're trying to create some kind of substantive right through the new version of COCA, which I don't think that's ever been our argument. We're simply saying it's sort of akin to section 1983 at the federal level. This is a gateway. This is a very large gateway to these rights, but it is a gateway nonetheless. And in doing the amendment in 2013, it has made the gateway much larger. There's a very brilliant lawyer in our office who was talking about the right to a jury trial as being sort of like a bucket. The right has always existed. It's constitutional in dimension. The state cannot limit the ability of a jury trial right specifically because it's constitutional. If the state wanted to limit it in the Constitution, would limit the Constitution. Can't do it with a statute. So, but there was a cap, however mistakenly or wrongly, over the jury trial right under COCA. But now that's been basically removed with this new exception, allowing litigants to have jury trials for money damages in the circuit court. I also want to touch very briefly on, there's some conflation. And I want to say presuppositionalism, and I don't mean that in an ad hominem or ad baculum manner. The Attorney General's office has been nothing but wonderful to work with throughout this entire thing. But I think that there is a conflation between immunity from suit, immunity from liability, and immunity from a jury trial. Okay. This is very important because we have a number of cases that Elia Companies, Friesler, and a few others that talk to whether or not the state can be subject to a jury trial. All of those cases that defendants rely upon, it's not talking about the fundamental right to a jury trial. It's talking about the fundamental right to a jury trial in the Court of Claims. Okay, that's a conflation of some things there. And so I just real quickly, looking at Ansel Dua, I want to read real quickly that the state's immunity from suit or its immunity to trial by jury are separate things. Okay. Again, looking at the constitutional precepts here, I don't see how they can say they're immune from a jury trial if a jury trial is of constitutional nature, coupled with the takings clause that is also of a constitutional nature. A statute, a subject matter jurisdiction, or a procedural statute like COCA cannot prevent the state from being subject to that. And I want to circle back real quick again to section 6421 and the changes made there. Originally, it was called trial by judge, Your Honor. That was the pre-2013 amendment was titled trial by judge. It is now titled trial by jury. So again, we're not saying that there's any substantive right that exists through this new amendment. We're simply saying that it has opened up a very large gateway whereby substantive jury trial rights, constitutional in nature in this instance, are more readily available to litigants and therefore must be tried in the circuit court. And that's our motion, Judge.
Thank you. In response, Mr. Fowler?
Judge, counsel is emphasizing that they view the 2013 amendment to the COCA as opening up this gateway, this new ability to have a trial by jury against the state that did not exist before. That position is simply contrary to the plain language of the very first sentence of section 6421. That sentence says very clearly, nothing in this chapter eliminates or creates a right to a trial by jury. The second sentence of 6421 goes on to explain that nothing in the chapter, nothing in the section deprives a person of a right to trial by jury that's otherwise provided by law. Otherwise provided by law, meaning it isn't created here in this section or in the COCA. It has to exist in other places like the Elliott-Larsen Civil Rights Act or the Government Tort Liability Act. So the plain language used by the legislature through the 2013 amendments illustrate that there was no intention to create the gateway that plaintiff is now asking to go through. This is a very clear, plain language case. A long line of case law shows for the state that this is as has always been the position and continues to be the position of the law in Michigan. The Hill Court in 1969, the Michigan Supreme Court said there is no right to a jury in a takings case. Because the case law is so against them, plaintiff is now thrust into the position in their reply brief of saying Hill is wrongly decided. The Michigan Court of Appeals in January of this year made very clear that the law in this regard is still good law, that there is still a requirement that a damages action against the state be in the court of claims and that there is no right to a trial by jury in that context. And because that case is so contrary to plaintiff's position here, plaintiff also has to, in its reply brief, say that case was wrongly decided. And that the Lim case, saying that takings cases that was decided pre-2013 simply no longer applies. So plaintiff's position here, Judge, is contrary to the plain language of the COCA, section 6421 itself, and is contrary to a long line of cases, both prior to and since the 2013 amendment.
Thank you. Do you have anything finally, Mr. Kelly?
I do, Your Honor. So counsel's talking about a couple different things, eliminating or creating any right in the statute. Okay, again, we're not arguing that any right has been created. We're arguing that the right to a jury trial, the constitutional right to a jury trial, has always existed, and that the state could not ever in the past, pre-2013 amendment, ever have abrogated that. Okay, and we cite a case in our reply brief that speaks very clearly about the power of the state. It's axiomatic that you cannot abrogate a constitutional right, even the state, especially the state. The Constitution exists to limit the powers of the state and provide for their powers in certain instances. Okay, so when counsel for the defendants is saying that we're arguing that it creates a right, we're not. We're saying the right always existed. We're saying that it was a mistake in the past that litigants weren't allowed to have jury trials for takings cases. But that's neither here nor there, because the amended COCA as it exists now does allow for it. Okay, so we're not arguing that it creates rights. We're arguing simply that it's a procedural gateway. Before Section 1983 was enacted at the federal level, you couldn't get to certain substantive rights that we knew existed anyway. It's the same case here. It's analogous. Counsel's talking about Hill and how we have argued, we've been put in a position where we've had to argue that Hill was wrongly decided and should be overturned. We're arguing that to the extent that it applies to this case, it would need to be overturned or it was wrongly decided. We don't necessarily agree that it ever even applies to this case. Defendants have argued both Kalamazoo and Hill to say contrary things. Kalamazoo talks about how under the 1908 Constitution, at least from defendants' perspective, under the 1908 Constitution, there was a right to a jury trial in takings cases against the state, but that language is no longer in the 1963 Constitution. Hill says the opposite of that. It says there was no right under 1908 or 1963. Okay, so we've got, even the courts don't agree, Your Honor, but regardless, if there was a right under the 1908 Constitution, as defendants argue, the 1963 Constitution says that a jury trial right shall remain. And as a result of that, we believe that it's very clear that it was pulled in from the pre-existing Constitution. Okay, so that's that. And then again, defense counsel falls back on this new case, the Elia company is a 2021 case that says that they say that there is no right to a trial by jury against the state. That is not what that case says. I will read from that case. It says no right to any suit against the state. As we have previously argued, defense is conflating immunity from suit with immunity from liability with immunity from a jury trial. And as a result, we think that that's why we say to the extent that those cases even apply here, we don't think that they do, they were wrongly decided anyway. But we don't think that that needs to be a conclusion because again, there's a conflation between suit, liability, and jury trial here, Your Honor. And the jury trials of a constitutional dimension, a taking is of a constitutional dimension. A number of these cases, Hill and Kalamazoo and other things the defense relies on, were decided pre-Penn Central, which was then late, and that's the controlling law for our case because this is a regulatory taking. So those cases aren't even contemplating a regulatory taking action under Penn Central, the federal case, as it was adopted by the Michigan Supreme Court later on. So I wouldn't even see how they could contemplate the cause of action at this time either, Your Honor.
Okay, I've had an opportunity to obviously to read your pleadings and papers, and I understand your clear positions, and it is not one where there's anything in a compromise. Either the court finds that the Hill precedent applies to this case, or I find it does not, and that somewhere in case law or statute or constitution that I would find that the plaintiffs in this case have a right to trial by jury. I do not so find. First, I do believe Hill is precedential and controlling. I do not find in any of the cases that are applicable to the state of Michigan that these plaintiffs would have a right to a trial by jury on the claims that have been currently pled before this court. And in that regard, I will decline to transfer the case or return it to the Macomb County Circuit Court. My law clerk, or actually my judicial assistant, will contact you probably this afternoon so that we can set a time where we can have a scheduling conference so that the matters that are presented in this litigation can be expeditiously managed and brought to an appropriate and just close. Well, thank you both very much. Have a good day.
Thank you, Your Honor.